This is a partial victory for former President Donald Trump, though not one in its entirety. The court ruling that under the constitutional structure of separated powers, the nature of presidential power entitles a former president to absolute immunity from criminal prosecution for actions with his conclusive and preclusive constitutional authority. It says that he is either entitled to or at least presumptive immunity from prosecution for all of his official acts. But this is the key. It goes on to say there is no immunity for unofficial acts. And this was really the question here. What constitutes an official act of the presidency versus the private act? What was Donald Trump doing as president versus a presidential candidate? This was what justices were questioning in these arguments back in April and could, of course, have great consequence for the prosecution of Donald Trump in the case brought against him here in Washington by special counsel Jack Smith. He, of course, in that case is charged with 4 separate counts, 2 of which potentially complicated by a Supreme Court decision from last week around what constitutes obstruction, because he has been charged with obstruction of an attempt to obstruct an official proceeding. But essentially what the court is doing here is ruling that Donald Trump is at least partially immune for official actions. It's going to be up to courts to actually sort through what is official and unofficial. What this all means, though, is that this is going to delay likely this case going to trial as we get closer and closer to the election in November. Joining me now with more is Bloomberg Wall Street Week host David Westin. David, of course, you also clerked at the Supreme Court. This is obviously a highly consequential ruling with not implications only for former President Trump, but all the presidents after him.
Yeah, I think, Kailey, you summarized it exactly right. I mean, on the one hand, the former president, Donald Trump, wanted just absolute immunity, the case to be over. That did not happen. The case will continue. At the same time, as you say, he does have immunity for official acts. The question is, what did he do that maybe was unofficial? That's going to have to be decided as a matter of fact as well as law. And at least from the oral argument, as you know, Kailey, President Trump's own lawyer said that probably should go back down to the district court. We have to determine that. So I think we've got some more litigation to go on. As you know, it's a heyday for the lawyers once again, Kailey.
Well, and the question is going to be, David, to what extent this can actually be sorted out in the process of a trial. If this is handed back down to Judge Tanya Chutkan, who is overseeing that trial in the Washington case, can actually the delineation of what is an official act versus a private act be worked out within the context of it? Or does all of that have to be sorted before the trial can formally begin? Well,
I'm speculating here, but normally the way this would work is you go down, you have pretrial motions, and there's motion practice before the district court. There may well be fact-finding. There may be some discovery about exactly what was going on behind the scenes, and then there'll be arguments, and then the court will make a ruling as to what in fact was official, what was not official, of what was alleged in the indictment, and they'll go forward. Presumably, if she finds some things that were unofficial, therefore are not subject to immunity, you go ahead with a trial, and then that could be subject to review and appeal.
And it would just extend this process even longer. That is what is also so influential about this decision, David, not only the precedent that it sets for the highest office in the country, but the idea that it's coming within the context of a presidential election cycle in which the defendant in question is running for president of the United States to take the Oval Office once more. We know that the court heard arguments in this case back in April, months ago. That was several months after it agreed to take up the case after the appeals court had rejected Donald Trump's claim of immunity. The court here has not only decided to hand it back down to courts, prolonging the process, but did so whether or not it is supposed to take politics into question, knowing that this likely would mean this does not go to trial before November.
Yeah, the Supreme Court in general, in my experience at least, tries to pride itself in not being political, sort of like the Federal Reserve Board says we really don't pay attention to that. We just take them as they come, make the decisions. But it's not just, of course, that he's running for president, but it's entirely possible he will become president again. And if that were to happen, he would presumably have the authority to stop the prosecution from going forward. I think that's a key element here, given how much delay is likely to happen.
Yeah, absolutely. I'm looking through the opinion here, David, to get to the dissent, one of which is authored with Justice Sonia Sotomayor, who says today's decision to grant former presidents criminal immunity reshapes the institution of the presidency. They say it makes a mockery of the principle foundational to our Constitution and system of government that no man is above the law. That's ultimately really what the court was deciding here, whether, in fact, at least in some cases, when acting in an official capacity, the president is above the law.
Well, that's one way to characterize it, and obviously the dissent would put it that way. If I can present the argument on the other side that was presented to the Supreme Court, it was that if you allow former presidents to be indicted for anything they did in office, it will really curtail the ability of the current president to exercise their discretion, that you have to be very careful. And this is why we have immunity of all sorts. I mean, immunity for police officers, for example, so that they're not too limited in how they exercise their discretion. So that would be the countervailing value. Certainly, we want no person to be above the law, including the President of the United States. That was decided in the United States versus Nixon, actually, with the Nixon tapes. That's been a bedrock principle. But on the other hand, you have to consider, on the other hand, could you be curtailing the ability of a president to exercise his discretion and do what he should be doing in his job?